I welcome you all to the inaugural workshop of Junior Faculty Forum for Law Teachers. And it's an initiative by Professor Tarunabh Khaitan, and it's possible because of Dr. Animesh Das from Xavier Law School and Mr. Prakash Meena from Campus Law Center, University of Delhi. So this Junior Faculty Forum is basically to help the young faculty members in law to develop their draft papers and make them even better with discourse and deliberations among the peers. So the author needs to be a junior faculty in law, but the participants may be the senior faculty members or the students as well. Today is our first an inaugural workshop of this junior faculty forum, and the deliberations in the workshop are meant to be more of supportive and constructive in nature. Tentatively, we've planned this to happen every Saturday, first Saturday of the month. And for today's workshop, we have the author whose paper we are going to discuss in the workshop, Dr. Mohsin Alam Bhatt, who's an associate professor and executive director of the Center for Public Interest Law at Jindal Global Law School, OP Jindal University. He graduated from Nalsar, Hyderabad, after which he completed his LLM and JSD from Yale Law School. His areas of interest are law and religion, equality and discrimination law, law and social movements, constitutional law and theory. Law School in the year 2016. The discussant today is a very well-known person, Professor Tarunabh Khaitan, whose initiative this Junior Faculty Forum is actually. He is a professor in public law and legal theory. He is a Hackney Fellow in Law, Wadham College, Oxford. He also is a future fellow in Melbourne Law School. Professor Khaitan is General Editor of Indian Law Review. He is also an Associate Director for India of Asian Law Center, Melbourne Law School. He has authored two wonderful books, one a theory of discrimination law in 2015, and the other one, Foundations of Indirect Discrimination Law in 2018. He's been awarded in the year 2018 First Latin Prize by Young Academy of Norway and the Center for Development and Environment, University of Oslo. Professor Tarunabh has set up this India Equality Program at the University of Melbourne through the awarded prize money. So we'll start today's paper workshop, and let me quickly get into the format of the workshop. Since this workshop is meant to be a pre-read paper workshop, that is why we would not have a presentation by the author of the paper. We would directly start with the comments by the discussant. I also request all our participants to share their questions and comments in the chat box so that we can pose it to the author or the discussant as the need may be. The paper that we are going to discuss today in the workshop is a beautiful, interesting paper on the functioning of Election Commission of India. It is titled Between Trust and Democracy, the Election Commission of India and the Question of Constitutional Accountability. So let us start with the comments by Professor Tarunabh Khaitan. Over to you, sir.
Thank you very much, Swati. Can you all hear me clearly? Okay,
yes,
I'll assume you can. Excellent, thanks. So, I want to start by thanking a fantastic team of the three conveners of the Junior Faculty Forum. Swati, Singh herself, who you've just heard from, Animesh Das, and Meena. And they have formed an extremely energetic, dedicated, and generous team, and have brought this together in record time since the inception of the idea, I believe under a month. So if that is any indication of how this forum might develop, I have very positive and ambitious hopes for it. So let's see how we begin today. We are also very fortunate to have a fantastic paper to discuss today. So I will follow the text of the paper very closely in my critique. which I will assume that you've all read. If not, much of the discussion may not make much sense to you, and we want to keep this workshop very much a pre-read workshop in its structure and character. Even if you have read the piece, it might help to keep an open copy in front of you, since I'll refer to page numbers and specific paragraphs frequently. So it'll be very much chapter and verse type of critique. And if you don't have it, I think you can easily download it by searching for Mohsen Bhatt and the title of the paper, which is Between Trust and Democracy, the Election Commission of India. I believe if you put that much in, it should take you to the SSRN page and you should be able to download the paper. So it'll be useful if you can keep it in front of you to follow the page numbers. So I'll dive straight in to the paper. And before I start my criticism, I want to say that on the whole, this is a fantastic paper, in part because Mohsen is fantastic, but also in part because this is the second time this paper is being workshopped. And I think as an author, Mohsen might have more to say about this, but workshopping really improves the quality of the paper by leaps and bounds. And I would strongly recommend any of you who are getting into academic writing to make it a law to yourself that you will not submit a paper to any journal without workshopping it at least 2 or 3 times in a group of clever, intelligent, and kind people. So that's one caveat. The second is that although excellent, the paper can be improved. Like every paper, I've not read a paper. It doesn't matter how clever the author is, it cannot be improved, and that inevitably means that the limited time I have will focus on criticism. And I don't want that to detract from what is a very powerful, insightful, and original contribution to the literature. So I want to make that quite clear. I want to start with the very first page of the paper, and the part of the paper that we don't often pay much attention to, but it is the part of the paper that the editors of the journal you're sending it to and the reviewers first read and decide what their view of the paper is. And this is clearly the abstract of the paper. So I want to just talk through and a lot of things I'll say is also based on my experience as a journal editor over the last 3 or 4 years. What I normally would look for in a good abstract would be 5 things in particular. They don't have to be organized in a particular order, but a good abstract would tell the reader all these 5 things. And I want to show you how Mohsen deals with those things or not, right? So the first is it should state the context or the problem, right? So what is the context within which this article is necessitated? What is the problem it is seeking to answer? That's the first thing the paper should tell us. The second is a central argument, right? What is the key thesis that the paper will argue? The third is its object of analysis. What is it? What is the thing, the institution, the actor, the judgment, the statute that is the focus of your analysis? Fourth, and this may be often implicit in the paper, which is your theoretical or methodological orientation that you will adopt in the paper. And finally, the paper should say something about the so what question, right? Why does this matter? Why should an author read this paper, right? Because every paper takes, serious reading, as you would have discovered, takes at least half a day, right? Why should I spend half my day reading this paper? So let's see how Dr. Bhatt succeeds in those things. On the first question, on the context of the problem question, if you notice the second line of his abstract, that broadly contains the problem, which is, but the criticism from opposition parties and civil society. But actually, let me start from the start of the abstract. Right? The first sentence, the Election Commission of India, clearly shows us what is the object of analysis. It is an institution. It is the Election Commission of India, right? So the third item, which is what is the object of analysis, is put up front, and the reader knows what the paper is about. And the title tells us too, right? The second line, the criticism from opposition parties and civil societies in recent years, especially the 2019 general election, of the Election Commission's accountability and transparency, right? That is the problem. Now, some of you might think that the problem is understated, right? Because because the criticism was actually a lot more biting than this. The criticism was that the Election Commission played as a particular political party's B team, right? But it's often strategically wise to not go all guns blazing, to not lose your audience too early by being, and these are strategic choices. You have to always think about what audience you're speaking to. And I personally think that Mohsin, in understating the problem, has been wise in not losing too many people who think, oh, this is just an ideological paper. I know what he's going to say. I don't want to read this, right? He's making it clear this was a criticism, and I'm an academic. I'm not going to be an activist in writing this paper, right? This next line, the ECI's constitutional accountability should not be treated as a transitory concern, right? Now here, I read this sentence as his implicit answer to the so what question, right? Why should I care about this question, right? And he's saying, look, Election Commission is important. It's not a transitory concern. It's central to democracy. This is the part of the abstract that I thought could be slightly stronger, right? Because this is the so what is a little too weak, and all it needs is another half a sentence to say why Election Commission is central to the innovation of democracy. It's implicit in this sentence, but it could be brought out more clearly. And then the bulk of the abstract, as it should be, is devoted to the central argument, right? So the rest of the abstract, you can see he very clearly, in plain English, tells us what it is that he's going to argue, right? The Supreme Court has co-opted the Election Commission as a ally in electoral reforms in its election jurisprudence. It clearly says that it has two distinct theoretical approaches, normative approaches, to thinking about judicial review. When it's reviewing politicians, it uses the discursive democracy model. When it reviews Election Commission, it adopts the model of trust, right? So that is very clearly told to us in the abstract. Excellent, right? There's one thing still missing, one factor still missing, which is the theoretical or methodological orientation. I already said that is usually implicit in the abstract. People rarely spell it out. And that again depends on your audience, who you're talking to. But when I read this abstract, it's clear to me that this is going to be a doctrinal analysis involving close reading of the case law, and it will use political theory insights, right? He's talking about models of discursive democracy, he's talking about frameworks of trust. So I know the method he's going to use, even though he does not spell it out for me, and that's fair enough. Abstract usually has a limited word limit, and that's fine, right? So he tells me everything. The main criticism of the abstract is that it could do a better job of answering the so what question, but he may rightly assume that his audience does not need to be convinced that this is an important question, right? Sometimes it'll depend on the question, right? This is clearly an important question, but anyway, so that's on the abstract. Let's move to the main article. Now, again, to frame my comments and things I'm going to say about the article, generally, there are 5 things that as a reader, I look for in a good scholarly piece, in a good academic paper. And these, sometimes some of this will track what I've said about the abstract, but some of them might be different. So the first thing a good article has to do is to have a clear, precise, scholarly question, right? It has to be an academic question. It has to be clearly and precisely articulated, and it has to be justified with the so what answer, right? Why should anybody care? And the so what need not be a practical answer, right? It can be a theoretical answer. It matters because it will aid our understanding of the Constitution. But you need to think about the so what. So that's the first factor in thinking about a good paper. What is your question and why does it matter? And be as clear as possible and introduce it early in the paper. The second thing that matters to me as a reader is how is the paper structured and how does it communicate its ideas, right? So here you have to try to think of a tired, bored reader who has a lot of other things and many pressing demands on her time. And why should she pick up your paper to read, right? So that is the reader. So the easier you make her task, by structuring it well in a way that is easy to follow one argument from another, by giving a good map of the overall argument up front, by communicating clearly and easily, by all those things you can win your reader. The third is comprehensiveness of knowledge. everything relevant to paper you have to put in, right? So there's no excuse for bad research in a scholarly piece, and that has to be done. You have to explain, and the fourth is analytic skills. Do the arguments work together? Do you engage with the opposition? So you're not being a politician, you're being a scholar. So you need to take the arguments on the opposite side seriously. Rethink your own assumptions if you need to change them, right? You have to justify your methodology. You have to see whether your methodology is rigorous. Does it work? Does your method answer the question at hand? And finally, what is it adding to the literature? Has this been said before? If it has been said before, why are you saying it? Right? You have to, if you're writing an academic piece, it has to have some measure of originality. You need not make a paradigm change, but you have to say something that is new to the field, that enhances our collective understanding of the field. Okay, so with those frameworks in mind, I'm going to take you to the second page. And as I highlight the problems, because I've already taken some time in setting up the framework. On the second page, Mohsin tells us that there is a dichotomy between reform and accountability, right? And he says in the last paragraph of the second page that while reform is a state of affairs, accountability is a process. Right? As a reader, I wasn't convinced about that. Surely, I thought what he means is not reform and accountability being in tension, because you can reform an institution to make it more accountable. It's not self-evident to me that reform and accountability are in tension. What it seems to me is the real tension here is between an institution's power or autonomy and its accountability. Right? And once you read the full paper, it becomes evident that, or at least to me, that is really what's at the heart of Mohsin's problem, right? On the one hand, we want an institution which is autonomous, which is powerful because it's doing something important. On the other hand, we also want it to be accountable, and these pull in opposite directions, and that is the tension. So this is, by the way, a problem with what I would see it as a problem with communication, right? That the reform idea confuses the reader. And notice that clearly Mohsin has picked up the reform idea because that is the language used by the Supreme Court in the discourse. So often, the popular discourse or the legal discourse or judicial discourse uses words carelessly. But that's not an option open to you as a scholar. Right? We have to clarify that language and say when they say reform, what they mean is this. Right? So, so that was the issue on page 2. When we move to page 3, this is a tiny point when he says, he gets on to the so what question. Right? So he talks in the big paragraph in the middle of page 3. He says, in the 2019 election, the criticisms were based on 2 main grounds. First was that its support for EVMs, despite all the evidence that there was something potentially wrong with them. And the second was the problems with the electoral rolls, right? And as a reader who's not an expert on the topic, but who looks at Indian debates regularly, I thought, well, surely the electoral schedules were also perhaps part of the problem, right? There were allegations about, there were claims that the schedule was designed to help a particular party. It's just a minor point about comprehensiveness of knowledge, right? Which could have framed, and there were challenges presumably as well. Anyway, so we move to the next page now. And there towards the end of that page, Dr. Bhatt gives us an excellent structure, a very good map of what the paper is in fact going to do. And that is indispensable to a good paper because it really, it shows the reader what the destination is, because that is your hypothesis. That's where you'll take them. And the structure shows the reader the route you will take, right? The various paths, the left and right turns you will make. And the step-by-step analysis just tells the reader what to expect. And it also keeps the author disciplined. Right? So I already know by reading so far that this paper is not going to be all over the place, right? It's a tightly argued, well-crafted, well-structured paper that will not take me a lot of time to figure out what is he really trying to tell me. He's done the hard work for me. So I'm already looking forward to reading the paper, right? Now to skip a few pages because the next section is a good introductory section. It's setting the context. It's setting up the context of the jurisprudence of deference of the Supreme Court towards the Election Commission, how the Supreme Court co-opted the election. This is a historical overview of a lot of the things that the reader needs to know. It's a good historical overview. So it's well done. My next problem crops up on page 8. When, remember the reforms versus accountability debate? It's a similar type of problem. Now on page 8, Dr. Bhatt starts telling us that the Election Commission's power are plenary in nature. And as I read this, I can see that he's borrowed the term from the judiciary, Justice Krishna Iyer to start with, and then repeated by Supreme Court judges, right? Now, given what I know of plenary as a term and what it means, it sounds odd to me that the Election Commission has plenary powers, because, so if you look at this one sentence towards the end of the big paragraph at the top of page 8, third line from bottom, in areas left unoccupied by legislation, the ECI has powers to regulate, right? Now that by definition cannot be a plenary power. An institution does not have plenary power is by definition contrasted with an institution that has residual power, right? So an institution that has residual power that occupies that ground that is left empty by legislation, by definition is not a plenary institution, right? So it, and this idea is repeated. Clearly the mistake is of the Supreme Courts, but it would have been better if it would have queried the court's use of the term plenary in a way that does not make sense. So again, on page 10, for example, if you look at the second part, the main big paragraph, and it starts these two elements, the second line says plenary power in unlegislated areas. That concept is meaningless, right? It sounds to me like an oxymoron. So that is again a small communicative point, but the point I suppose I'm belaboring it, but the point being made is that often the judges are practical problem solvers. They are not theorists. You are scholars, right? So you have to clarify their concepts as well and not just adopt their concepts as a given. And sometimes, tell the judges that, no, you're using language unwittingly. And perhaps some of the later cases where courts start intervening, even when Parliament has occupied the ground, that distortion can be explained by perhaps a mistaken early use of the term plenary, right? Because the court starts with saying it has plenary power, but in areas that are unoccupied. And later, even when Parliament occupies the ground, has clear rules, the court says, no, the ECI can act, contrary to primary statute, right? So maybe this is not just a grammatical mistake, right? Or even if it was a grammatical mistake, that is having serious implications for doctrine, right? And one would expect the author to tell us something about that. The other thing that was interesting about this residual power doctrine was the parallel, and this is an interesting aside, right? So this is maybe some comparative law might have been useful here. So in the UK, for example, the executive cannot do anything unless its power flows from a statute. There are two exceptions. There are 1.5 exceptions to this. One is if it can show it has a prerogative power, which is a small historical set of powers increasingly diminishing. And there's a debate about whether there's a third source of power, right? But that is only implied powers, and let's put that to one side. But the main power of the executive is if the executive does anything, anybody can go and, well, if you are affected, you can go to court to say, show me the law. Right? Show me the law on the basis of which you've done this. And, we've seen in the Kashmir blackout, for example, a lot of questions people said, what is the law? What is the basis on which you've done this? Right? Now, the Indian Constitution, however, has been interpreted differently, where the Supreme Court, I don't think this has been clearly argued, but the 7th schedule has been read in a way that that itself has become a source of not just legislative power, but executive power. So even if Parliament is not acted, every entry in the 7th schedule gives rise to executive powers by itself in the absence of legislation. So I'm wondering whether the Election Commission's powers are being read in the same way as executive power in India, and whether there's a parallel here. So some interesting footnotes were possible there, but one article cannot do everything. So often things that a reviewer says are things that, he or she might like to see, but an author obviously has to make careful choices. Okay, so let's move to page 12. This is where Dr. Bhatt introduces the idea of discursive democracy. Now, this is really interesting. I read this, I set up, I think, okay, so he's not using the word that I usually come across, which is deliberative democracy. He's not using the word participative democracy. He's not using, so the labels that I'm usually familiar with. I want to know what the discursive democracy is, and he does a pretty good job of explaining what discursive democracy is. Discursive democracy is a democracy which facilitates free exchange of ideas, right? So the most important democratic value is free speech and expression, of political speech and expression, and once that's permitted by allowing voters an informed choice, that is the idea of discursive democracy. Dr. Bhatt gives a good explanation of like a pithy statement, almost a definitional statement, but that's not a problem. My problem is I want to know if whether this term is his term or the court's term or a term borrowed from a scholar. And it's not clear in that discussion where the phrase comes from. If it is something he has come up with himself, he should take credit for it, right? And maybe just say my term or whatever, because it's an interesting term. If he has borrowed it, obviously he decided, and maybe he has enough carelessly missed that. So then I want to draw your attention further down the paper to page 15, right? Where in the big first paragraph in PUCL, now here, there's an issue that often comes up with many authors. They know so much about the topic that they often don't think about what the intelligent but uninformed reader does not know. And they often assume a lot of knowledge, right? So sometimes being an author also means forgetting everything you know and see the paper from the point of view of somebody who does not know the paper, right? So here, I think when he says in PUCL, I want to know what the facts of the case were. What had Parliament done after the ADR judgment that gave rise to a new cause of action? The first time you introduce a new case or a new fact, give the context that leads up to it to explain how we got here, right? Okay, and then I'm going to skip a few points because I'm getting section 4, trust and accountability. That discussion is fantastic. It starts on page 18. The way he theoretically pits the two ideas against each other. Why? So if you see at the bottom of page 20, the idea of credible commitment, trust is directly proportional to the extent of discretion to institutional actors. This is really, really insightful, that the more we want to trust an institution, the more we want to empower it, and therefore accountability suffers, right? So we expect public reason-based accountability from institutions we don't trust, like politicians. But institutions we trust, we give deference to, and hence the tension between trust and democracy. And that's really nicely done. There are little issues which I'm going to skip, but I want to draw your attention to page 24, where towards the end of page 24, Dr. Bhatt introduces an idea, a very important idea for his argument to rest on, but he does that far too late and far too quickly. So let me quote, he says, the notion of accountability bound by trust would require other institutions to secure the conditions of credible commitment. Right? For those of you who have read the paper, you know what it means, but basically my reading of it is what he's telling us is, what all that other institutions can do for fiduciary institutions is structural accountability, but not operational accountability. All they can do is to make sure that their structure is free and independent of political interference, so that they have, in Dr. Bhatt's words, secured the conditions of credible commitment. But the accountability is based on reputation of the individuals involved. So the accountability can only be internal, right? And that's, if I'm reading that right, that's a key theoretical move. And it's not clear to me, for example, why the ECI cannot have operational accountability to, say, a parliamentary committee made up of multiple political parties without governmental majority. So it's a different type of accountability. It's not to the judiciary, it's to politicians. But that will be operational accountability. So it's a key move, it's an important move, but done too quickly. And sometimes this can be a problem in a theoretical paper, right? That you're making an important argument, but you don't spend the time it deserves in the paper to really to really convince the reader of the point, right? And I'm sure that Dr. Bhatt will have good arguments against it. So that was one weak point. Now, the next section is a fantastic survey of case law to prove the theoretical framework is actually true in the Indian context. I'm going to skip all of that with only one small comment, which is that I'm not an expert in the case law in this area, so I can't know whether Dr. Bhatt has cherry-picked these cases to suit his analysis and whether there are other cases that are sitting there that he has just ignored, because that would be bad practice, or he has actually been a fair reporter and told us about all the cases that are there, all the relevant cases, and given us a fair picture, right? So I'm not an expert, I don't know that, but an expert reviewer will check for that, right? And that goes to comprehensiveness of knowledge, that you don't cherry pick, you don't make your facts fit your argument, you make your argument based on the facts as they exist. Final point, and then I'll close, which is that on the very final page in the conclusion, I think the conclusion is beautifully done. It ties everything together. The only thing I did not like in the conclusion was in the penultimate sentence, he introduces the idea of dialogic review and says why that will solve a lot of these problems with accountability of a fiduciary institution. Like the previous comment, it's a very important idea, probably could be doing a lot of work, and unwise and not recommended to throw in at the very last moment, right? I would leave it out or leave it as an open question, right, with some footnotes, but I would not throw it in at such a late stage. It's a weighty issue, and leave the reader slightly befuddled. So for all those criticisms, I want to commend this paper to Dr. Bhatt. I think it's a fantastic piece, and I'm pretty sure that it's going to improve our understanding of the Supreme Court's jurisprudence in relation to election law in India. Thank you very much.
Thank you, Professor Khaitan, for a beautiful critique. I think in the start, when you talked about the 5 pillars of abstract and those for a good paper, that would be very useful for all the participants. And regarding the critique, let us hear from Dr. Mohsin Alam Bhatt now. Over to you.
Thank you so much, Swati, and the rest of the excellent team for organizing this, and of course, Tarun, for not only conceptualizing this forum, which I think is a wonderful, wonderful opportunity for scholars, and thank you for also having me, being a quote-unquote young scholar. Always nice to be called that. I think one of the most valuable things about this exchange, and is which Tarunabh already mentioned, Professor Khaitan already mentioned, which was the value of workshopping papers. Because as all of us have seen, an excellent, kind, generous, and incisive reviewer and a peer is absolutely essential to improving a paper. And the granularity through which Professor Khaitan went through the paper is something which anybody who has ever attempted to write anything would really appreciate. It's really an honor, and it's good fortune, really. Now, from this perspective, considering what the context of this conversation is, I will not spend a lot of time defending the substantive claims, which I'm sure some of the other people who are here may have specific questions related to the substantive arguments I'm making. So, but I'll pick up from Professor Khaitan the tenor of this conversation, which is trying to explain how I ended up making the mistakes which he pointed out. Because I think that would be a useful way for me to also make sense of my own writing, but also for the other friends who are here, friends and colleagues, to also see how workshopping actually improves writing. The previous round of workshopping on this paper, actually, as it turns out, was also before Professor Khaitan and other senior colleagues. And many of the things which have changed in the paper happened because of that conversation. And in fact, some of the errors which Professor Khaitan, which I completely agree with, are errors of a certain sort of style, are also interestingly a result of the changes which I made in the paper. So the paper improved, but there were certain problems which remained because they were like a new set of things I introduced in the paper in order to complete that argument. And that sort of reminded me why this workshop is so valuable. So let me just pick up 6 things which Professor Khaitan talked about and make this into a bit of a confession. How come those sort of things weren't as improved as I thought they were? So let's start with the first one, which is the question of reform and accountability. Now, why did I say this sort of rather cumbersome thing right in the beginning of the paper? And I did that for 2 reasons. The first reason is what Professor Khaitan identified as the burden on the author to tell his or her readers what is the original contribution. And I wanted to treat this dichotomy between reform and accountability as the original contribution of this paper. The reason is that as an excellent political science scholarship has taken the question of institutional design of the Election Commission very seriously. So what I meant by the word reform was actually design. What I essentially meant to say was that lots of scholars have talked about, well, how should the CEC be appointed? How many members should there be? You know, whether there should be a ECI secretariat, which is autonomous from political interference. For me, these are a range of design questions. And that is what I mistakenly called reform. Because as Professor Khaitan pointed out, the right word for that is not really reform. But I think the lesson for me was that I was really saying something completely different. And with the language I have adopted, that got mistranslated in writing. So what I intended to say, and I think that is the point of the paper, is that there's a fair bit of preoccupation with the question of institutional design. Institutional design is a separate issue from a question of ongoing, what Professor Khaitan called operational accountability. And both those things have to happen together. There's structural accountability and operational accountability. And I'm going to steal those 2 ways of looking at it. And that's exactly what I wanted to say in the beginning. But I was clearly not clear enough or careful enough with using the word reform, because the word reform may be understood in different contexts and by different people in different ways. Now, second thing, which very nicely pointed out by Professor Khaitan, the word plenary. Now, I feel, at least when I was writing it, and I hope at least that the readers would also have realized that there was a reason why I italicized plenary. I actually don't like the word plenary. I just don't explicitly say it. In the sense, there's a later part of the paper, I basically say that, this whole business of the court calling ECI plenary, etc., is a red herring. That is not really what is going on here. While the court is saying in Mohinder Gill and a bunch of earlier cases that, well, the reason why the ECI has the jurisdiction to do it is because this is a vacuum, legislative vacuum. But later on, through the range of reform cases, I argue essentially that actually is not what is going on. The business of this area being left unoccupied by legislation, which the court is calling plenary, is actually not what is going on in these cases. So while I was critical of the word plenary, I just borrowed it, and I think it's useful for me now to flag my worry with that word. Because when I was reading the portion again while Professor Khaitan was talking, I realized it may, for many readers, seem like I'm endorsing that particular, which is definitely not what I'm doing, which may become clearer later, 3-4 pages later, but I should really say it up front. Now, which is, I think, the same issue which came up with the phrase discursive democracy. This is not what the court says. And of course, somebody is really sort of reading generously and carefully and goes back to the cases, then the person knows that, well, I know that these cases are not explicitly consciously at least using the framework or explicitly using the framework of discursive democracy. This is my framing. Perhaps the reason, again, as a matter of confession, the reason I did not spend a lot of time on it is because this is not what I thought was the original contribution of the paper. There are actually some excellent scholarship on how the Indian Supreme Court has used discursive, deliberative, or that can be a debate. And I just didn't want to get stuck in that debate. So for example, Professor Manoj Mate has written a couple of really good papers, and he has a full-blown assessment, theoretical assessment, and comparative assessment of how, in these cases and even beyond, the Indian court has paid a keen sort of eye on democracy, discursive, deliberative democracy tools. But again, that doesn't take away from the fact that I should have clarified where I am, or if I was relying a lot on others, I should have also said that up front. So that's a very useful suggestion. Let's go to, again, another important point which Professor Khaitan raised, which is this rushing over cases, not giving facts. This, and in fact, it is more, as in this deserves more criticism than Professor Khaitan gave. The reason is that Professor Khaitan talked about page 15, where I did not mention the facts of PUCL. Actually, I do something even peculiar because I got bored of writing all these facts, which again is a good reminder in workshops to sort of spend a lot of time on it. What happened between ADR and PUCL is that ADR laid out a series of transparency requirements, and the government passed an ordinance. Eventually, the parliament passed an amendment, which essentially left out a range of these requirements, and that came up in challenge in PUCL. On page 13, I say that, well, in ADR, it was in the absence of legislation, and in PUCL, it was after legislation, because at that time when I was writing clearly, I was more interested in exposing this whole red herring nature of the plenary unoccupied legislation field. But in doing that, I should have clarified the facts. And I think just going slow in that in that part of the paper would have been helpful. I think I was just zooming through all these cases because I just wanted to reach my argument. So that's a good reminder, be slightly more patient while talking about it. Now coming to, and I'll just say one more thing, and there are lots of other things I wanted to point out, and just also to point out how useful these comments are. But just one thing about the question of dialogic review. When again, a lesson on why these workshops are useful. So in the previous workshop, I actually had started the paper, the tenor of the paper was different. The tenor of the paper was much more critical towards the ECI. And essentially, I had also argued that the framework of trust is bad. And the only viable framework is democracy. And that is essentially what I was arguing in the first version of the paper. After that conversation, the whole business of the framework of trust having its own attendant accountability features, what Professor Tarunabh called structural accountability features, that became clearer to me. In fact, the previous paper seemed just too critical. In fact, in some of the conversations which we were having in the previous workshop, there were many other scholars from other countries, and they were like, well, can you imagine India without a bureaucratic organization? Let's at least prize what you have. And I think that conversation is really important. And it sort of dawned on me that perhaps I'm being dismissive of the framework of trust a bit too early. And a lot of changes which I brought in after that conversation, I think need to be seamlessly now melded with the rest of the paper. So for example, the dialogic review was part of it, which is when Professor Khaitan said that, well, there could be political ways of introducing operational accountability. So dialogic review was one way of just putting that in order to also defend judicial review as a way of going about it. That deserves much more time and space. So I actually think that the conclusion has to be improved. In fact, I need to have some sort of defense of the courts being, if not perfect, but a well-suited institution to guarantee operational accountability. So that has to be there. I can't drop it, but I have to spend more time on it. And at the same time, Professor Khaitan's critique on page 24 about rushing through the argument around trust, framework of trust, and its attendant accountability features. That again is something which I added in the previous writing. In the next writing, I have to just explain that, because I have now come to believe, after the previous round of presentation, that the framework of trust has really powerful tools of accountability. And after writing this, I've realized that there needs to be a stronger critique against the Indian courts actually not even enforcing the tools of accountability within the framework of trust. And that actually is a different paper. But at least in this paper, there has to be a full account of the kind of tools that already exist in framework of trust. before one critiques the court, and to say that please borrow tools from the framework of democracy to improve operational accountability. So this was extremely useful, and I think, and specifically why this conversation has been useful is because it allowed me to really think about these two papers, or at least two stages in which this paper was written, and in the third writing, which I hope to do soon, would be to sort of seamlessly wed all these things together. Yeah, thank you.
Oh, thank you, Dr. Bhatt, for the feedback. We have one comment as well as a question by one of our participants.
Sorry to interrupt, Swati. Can I just take a minute?
Yes, Professor Khaitan.
I just want to highlight
Sure,
three things about Dr. Bhatt's response. The first is that it's not just giving criticism that is a skill, but receiving criticism is also a skill. And Dr. Bhatt has amply demonstrated to you how to receive criticism well, which is not defensively. You don't have to accept all the criticism, but defensiveness, criticism in our scholarly context is service, right? Somebody is taking their time for no reward, and it's usually a thankless job, to make your work better. It's not an attack. So sometimes it can be done less generously. So that's one thing to notice in Dr. Bhatt's extremely gracious response. The second is that, as you mentioned, you'll often receive criticism which pulls in opposite directions. And different people will see things differently and sometimes give you completely contradictory recommendations. You don't need to accept all the criticism you get. You need to think about all the criticism you get. And obviously, sometimes, multiple stages can also clarify sometimes you can overcorrect in light of one criticism, and then a second stage of revision can help that. And third is that one paper cannot solve all the world's problems, and one paper must not have everything clever you've ever thought of. Right? Leave some things to another day, and it's okay to flag and bracket and say, this is a problem. I have views about it. I'll get to it in another paper. Thanks for the intervention, and sorry to interrupt. Swati, over to you again.
Yes, absolutely, Professor Khaitan. So actually, paper writing is a craft, it's an art. And this workshopping and discussing it amongst the peers and with seniors and students refines the craft. And yes, taking the criticism this well helps, of course, makes this refinement even easier. So we have now some comments and feedbacks by the participants. We'll start with the comments and feedbacks now. We have our first comment followed by a question by Dr. Manvendra Kumar Tiwari. He says, my reading of the paper suggests that the lack of the reason given by ECI for its decisions is one of the main problems, since lack of reason brings entire deliberative discourse to a grinding halt. What if, instead of not reposing trust in ECI, the Supreme Court starts asking ECI to give reasoned arguments for all its decisions while continuing its trust in ECI by not subjecting those reasons to judicial review? This question is for the author, Dr. Bhatt.
Would you want me to respond to individual, or you want to take some questions? I'm happy to do.
As you suggest, sir, we can take 2-3 questions, or if you want to do it one by one.
I'm happy to take this question. So
right.
I agree with Mr. Tiwari, though I think we need to, and because it's quite difficult to get a clear sense of the question. So please forgive me in case I've misunderstood. So if I've understood the comment / question correctly, what Mr. Tiwari is saying is that there is a fundamental problem with the way the courts have engaged with the Election Commission because they have not demanded transparency of reasons. And in order to strengthen trust in ECI, it would be a better strategy to demand those reasons. Perhaps where I'm slightly lost is towards the end when Mr. Tiwari said that not subject those reasons to judicial review. So I'm perhaps not completely clear about the last bit, but the rest of it I completely agree. I think that actually is the soul of my argument as well. that there is a certain kind of balance that one needs to strike between respecting competence, autonomy, and discretion, which flows from the framework of trust. And I'll clarify that as well, because I do clarify that implicitly, and perhaps I need to clarify that more, but I'll just come to that. So there's a need to balance that with the need to have transparency in terms of reasons which the Election Commission has provided. And I do substantiate that with examples. I think one extreme case of that is what happened with the electoral bonds case, where this has essentially moved into the sealed cover jurisprudence, so to say. I fear that that is not sort of an exceptional, quirky thing which some judge has done in the court. That I try to argue that that is actually part of a longer trajectory in which the court has dealt with the Election Commission. But just a note of caution, because the word, I use the framework of trust in a very specific way in the paper. And I mean by it institutional trust, particularly between the court and the Election Commission. If you recall my narration of the German voting case, which involved the electronic voting machines in Germany, the German court also uses a notion of trust, but it uses the notion of public trust. And I just wanted to sort of flag that, because the nature of public trust and the implications of demand of public trust is actually very different from the way I use framework of trust. In my argument, the German court basically said that in order to have public trust, there needs to be transparency. So the notion of trust there was used in order to demand openness of reasons and transparency of the process. Whereas the way I use the meaning of framework of trust is different, which is to have insulation and autonomy and discretion. So if Mr. Tiwari means that in order to have public trust, there should be transparency of reasons, I agree with that, and definitely that would be something I would endorse in my paper.
Yes,
I hope I've answered that, but please forgive me in case I've missed any substantive aspect of the question.
Yes, thank you, Dr. Bhatt. We have an extension of the same. He further says that in addressing issues which require domain expertise, we see deference from the courts towards the decision takers. This is not necessarily because of trust, but also because of courts' lack of expertise in being able to review the decision. So how would you see this aspect?
Absolutely, I agree with that. So in a part of the paper, I do, in a way, provide an account in defense of the framework of trust. I'm not dismissing it. What essentially I argue is that the core of the framework of trust, the basis of trust, is one, competence, two, the ability of the fiduciary agency or entity to maintain credible commitments, two, secondly, long-term policy goals. So the whole point of having trustee or fiduciary institutions is precisely because they are expected to be and meant to be competent. They are meant to be insulated from ordinary political interference. Let's think of, for example, central banks. The whole point of an RBI, ideally, or any other central bank, is to ensure that it is not subject to what the finance ministry says, because it is planning something in terms of the long-term aims of the polity. So in that sense, it's both expertise as well as certain form of insulation. In the paper, I argue that it actually, in the concrete context of the Election Commission, it is functional, political, and ideological trust. So in those three ways, the Election Commission is expected to be independent and autonomous in order to respect in order to respect credible commitments in the long run, because it is functionally competent, it is politically insulated, and ideologically neutral. And in that sense, that gives a very good basis for the court to have a certain attitude of trust towards the Election Commission. My only note of caution, and that is what animated my argument, was to really raise a question of whether that is enough in all cases. Does that resolve all the different kinds of accountability problems or is accountability a blind spot? Even if this framework of trust is useful and makes a lot of sense, do we still need to have more tools in order to have accountability? And therefore, there's the argument that fine, of course you need to have framework of trust, but at the same time, in certain instances, you need to also be much more sensitive to other concerns of operational accountability, which would be possible if you borrow from the framework of democracy. So I'm definitely not minimizing the importance of the framework of trust, particularly when it comes from the perspective of expertise. I respect that position completely. Thank you for that.
Thank you, Dr. Bhatt. So here we have a question and then a clarification by John Sebastian. He asks for a clarification. He says, have you explored the theoretical possibility of the framework of trust and discursive democracy not really being completely opposed to each other? He asks this for two reasons that he states. First, it doesn't seem necessary that the three features of systems of trust, that is autonomy, competence, and independence, are necessarily opposed to the duty to give public reasons. Second reason that he gives is if the duty if you add the duty to give public reasons for your actions, are you not moving to the discursive democracy model anyway? So how would you, for instance, compare the accountability mechanisms of the ECI in the form you have proposed with an institution like the Supreme Court itself, which is also an unelected body relying largely on competence and independence as well?
Sorry, Swati, can you just repeat the beginning of the second question? I lost you there.
Yes, he says that how would you, for instance, compare the accountability mechanisms of the ECI in the form you have proposed with an institution like the Supreme Court itself, which is also an unelected body relying largely on competence and independence as well? So are there important differences between these institutions which would require different accountability mechanisms, and why?
Right. Thank you, John. Good to be receiving your questions. Quickly, as in these are two excellent points again. To the first point, I don't necessarily think that the two frameworks are necessarily opposed to each other, in the sense, if by the word opposed you mean they operate to the exclusion of each other. I am not suggesting that. I think for major part of the paper, I do point out that they're different. And they're different because they actually emerge from very different intuitions about the institutions and different kinds of background assumptions about how those institutions should have relationships with other institutions. I'll give you one quick example. For example, I believe that the framework of democracy, particularly when it has been articulated without explicitly so in the cases involving electoral reforms, that those cases are really emerging from an intuition of distrust towards political actors. Whereas the framework of trust is exactly the opposite. It comes from the understanding that certain institutions have to be trusted because they are competent, they are neutral, etc., etc. Similarly, the framework of trust is interested in securing the vernacular reason from necessarily being interrogated in the public, with the assumption that certain technocratic expertise is something which is inaccessible to people. And therefore, one must respect a technocratic institution taking certain calls, even if it may not be public. Whereas the framework of democracy is based precisely on the opposite understanding. That, say, for example, political actors must tell us everything. The reasons must be public reasons. They must be translated as public reasons and be subjected to the rigors of democracy or any other form of accountability. So they are not opposed to each other in the sense that they can and do exist together. I do believe they should exist together, but they are different. And I would argue that and I hope that that it is clear from the paper that I do argue that both of them must exist together. just that they are different and they have different tools to generate accountability in different senses. The second point, very quickly, yeah, that is precisely the reason why I was worried about not having a defense of judicial review here. Because, and there are two reasons. One is a very sort of practical assessment whether the Indian courts, particularly today, are best placed to ensure accountability from another institution. And the second is, why is it, as you, I think, very well put it, why is it that Election Commission is also in many ways an independent institution? So is the court. Why should one be subject to the other? And hence, I felt that there was a need to have some sort of defense for the courts being a good place to be doing this. And hence, the business of dialogic review. I'm happy to defend dialogic review here, but that will take a long time. But we can always have a conversation about it later.
Thank you so much, Dr. Bhatt. Professor, would you like to make some on the discussion going on?
Okay, thanks, Swati. I just wanted to follow up on John's question, or at least the tenor of his question, which is to challenge the sharp divide that you have suggested. And so here is one way to think about the two cases, ADR and PUCL. We talk of them as cases pertaining to a framework of distrust, of discursive democracy. It's possible to read them differently, at least if we sharpen the distinction between structural accountability or the design questions and operational accountability, then both ADR and PUCL cases don't actually pertain to operational accountability at all. Both of those cases also pertain to structural accountability of politicians, right? So, so just in the same way that by ensuring sort of certain structural features of the Supreme Court, it thinks we will, of the Election Commission, the court believes we can have the best election commission that's possible, and then we will not interfere in what they do, right? Maybe one way of reading ADR and PUCL is to think the court is doing exactly the same thing with politicians, is that by empowering the voters, giving them more access to information and making democracy as discursive as possible, it's saying we are designing political institutions in a way that will give us the best politicians possible, but operational accountability, when it comes to that, what politicians in fact do, will be deferential. And as you know, a lot of my work and other people's work recently has also argued against the narrative that Indian Supreme Court is a particularly activist court, right? So if there's any truth in that, then maybe there's a dichotomy where the Supreme Court is very interventionist when it comes to how to structure the political field, but also deferential to politicians when it comes to political decisions, with a few exceptions, right? So if there's any encroachment on judicial review, they come out very strongly on it. But it's very hard to find a case where Article 14 violation has actually led to striking down laws. There are cases, but it's rare. So that's sort of one thought which I think pushes you in the same direction as John. Another question from the opposite end, from a theoretical end, is does your distinction between sort of the two normative frameworks, to what extent does it map onto the discussion that is currently emerging on the fourth branch institutions? So as you know, Mark Tushnet has a paper, Michael Pall has been writing about it, a lot of people have been, Charles Formbad has been writing about it, in other jurisdictional contexts, this emerging idea that there is a separate fourth branch, which is not the executive, not the legislature, not the courts. It has the Election Commission. Everything else is unclear, whether RTI Commission is in it, whether human rights bodies are in it, whether Equality Commission is in it or not. But maybe what you're saying is that judicial review for the political branches, which are the executive and the legislative branches, should be one of discursive democracy, or one could argue, right? Whereas judicial review for fourth branch bodies should be one of trust. So that would be one way of defending what the court is doing, to say that surely that makes sense, given that on the one hand you have, and this is, you referred to this political science debate in your paper, but the political branches are agent of branches, right? They're not fiduciary bodies. They are, or at least so the argument goes, right? That the legislature and the political executive, at least, are agents of the people. They're not trustees of the people. Right? The job of the court is to make sure that they don't digress very far from what the people want. Whereas the fourth branch institutions are not agents of the people, they're trustees of the people. And therefore, the role of the court is also to trust them while maintaining their non-partisan status. So those are two related questions.
Yeah, well, I'll take both those things, and I think I need to really consider more, because your questions and also John's comments, I think are pushing me to think more about the implications of the argument. And I think that's true, even though I started off the argument as historically, started off the argument being much more critical to the framework of trust. I think what I discovered was that the fourth branch literature does not use the word trust, which I think is an error. I think what is really happening here is we need to have a stronger account of trust. I use it as a framework in order to characterize the relationship between the court and the election commission. I think the implications are much beyond that relationship. I think the way you put it is how I'll endorse it, which is that what is interesting about fourth, fifth, sixth branch institutions, as well as the court is also a trustee institution. And that is exactly what I think John was also asking. That, well, ECI as well as the court, they seem to be similarly placed. So is the RBI, so is the CAG, there so many others here. And I take that, absolutely. But that is slightly beyond, that is completely beyond the scope of my paper, because I was more interested, at least started off with figuring out the relationship between the court and the ECI. But while doing that, I've realized that the language of trust is what makes these institutions, fourth, fifth, etc. branches, including the court, interesting and unique. And that would raise a separate issue about, well, if that is what is going on with these institutions, which are trustee institutions, how should they behave towards each other? Now, this is not a new debate. In fact, in the European context, this is a long old debate which has been going on for decades now. And I use a lot of that literature in order to understand the relationship between EC and the court. And that is where this sort of tension between accountability and autonomy has come up very strongly in the literature around the Commission and the European Union. And I do think that literature does throw up really interesting ways of looking at fourth. We need to have a stronger account of trust. I use it as a framework in order to characterize the relationship between the court and the election commission. I think the implications are much beyond that relationship. I think the way you put it is how I'll endorse it, which is that what is interesting about fourth, fifth, sixth branch institutions, as well as the court is also a trustee institution. And that is exactly what I think John was also asking. That, well, ECI as well as the court, they seem to be similarly placed. So is the RBI, so is the CAG, there so many others here. And I take that, absolutely. But that is slightly beyond, that is completely beyond the scope of my paper, because I was more interested, at least started off with figuring out the relationship between the court and the ECI. But while doing that, I've realized that the language of trust is what makes these institutions, fourth, fifth, etc. branches, including the court, interesting and unique. And that would raise a separate issue about, well, if that is what is going on with these institutions, which are trustee institutions, how should they behave towards each other? Now, this is not a new debate. In fact, in the European context, this is a long old debate which has been going on for decades now. And I use a lot of that literature in order to understand the relationship between EC and the court. And that is where this sort of tension between accountability and autonomy has come up very strongly in the literature around the Commission and the European Union. And I do think that literature does throw up really interesting ways of looking at fourth branch institutions. And that is exactly what I've been working on now. So thank you for that.
Thank you, Dr. Bhatt. We have a question for Dr. Bhatt by Anand Sangal. He says, I see a pattern in the litigation before the writ courts when it is about the electoral reforms. Most of these cases, be it the ADR, PUCL, etc., are filed by the civil society organizations. Should we conclude that the court's tendency to trust or defer to election commission is germane in the fact that these issues have seen some activism on the ground or participation from the pressure groups? Something which Professor Khaitan also asked, whether this kind of trust is visible on all other constitutional bodies.
I think I'll try and read it myself again. So if I understand Anand's question, well, and please again forgive me in case I misunderstood it, but you can always type out, and I'll read your chat so that I don't miss anything. If I understand Anand's question, it is the fact that ADR, PUCL, and other cases have had a fair amount of mobilization on the ground, either in terms of civil society or otherwise, led to or influenced the court's attitude towards the election commission. So in other words, is there a relationship between the court adopting a certain framework of trust and political context? If this is the question, it's an interesting point. I haven't in the paper tried to assess the relationship between the political context as much as I could have. But of course, you're completely right that that is a really relevant thing to consider. Also, in my narration in the paper, I have not spent enough time talking about how the political context, both electorally and non-electorally, may have influenced these things. So that is a really interesting and important and relevant thing. Of course, as Professor Khaitan said, one can't talk about everything, but that is definitely another way of looking at it. So I need to consider this a bit more, but if I have to go on a limb, I would say that I suspect that is true. I think you're right. And while I was preparing for my remarks today, one thing which I realized was, I started the paper with quoting Rudolph and Rudolph, who talk about how the Supreme Court, they also mentioned the president, one can debate that, and the election commission have become these new institutions which have taken a place of pride. It's their words. I think in many ways we need to now reconsider that thesis. A lot of the literature on the election commission, particularly the expanding powers of the election commission, were really written in the 1990s and early 2000s. And these are the years which did not have a very assertive executive. This is pre-2014 literature. And I think increasingly the changing context of of our politics will push us towards reassessing the ECI's role. The paper itself, my paper, was in a way emerged from that concern because obviously there is a unipolar political, at least at a national level, a unipolar political context. And obviously those things are, at least the political scientists would tell us, those things are influencing the way ECI as an institution will behave. In a sense, to now respond to your point directly, it's completely possible, and I'll say this subject to further thinking, that a fragmented political electoral context, a very strong Supreme Court, at least a very assertive Supreme Court, which had a lot of breathing space, and multiple parties which were in opposition, which wanted an election commission which would be an insurance for them. These are all the different arguments which have been made by scholars, allowed for the court to have a certain attitude towards the election commission. That may not last forever. Definitely part of the story would be what happens on the ground with civil society mobilization, a strong civil society, large number of powerful opposition parties would shape these conversations definitely. But I now have a feeling that we may have to reassess a lot of that scholarship, not because that scholarship was wrong, but it was written about a certain time in our political history. There's some really interesting literature now, and I actually, because he's here also, recommend Professor Khaitan's recent writing on the assertive executive. And I think that is now the context in which we also need to look at the election function.
Yes, thank you, Dr. Bhatt. We have one question that is generic, exposed to Professor Khaitan. The question is by Shantanu Sabha Pandit, and the question is regarding the cherry picking that Professor Khaitan mentioned. So the question says that how to indicate that the author has randomly selected relevant cases to make a point as opposed to cherry picking. And also, what are Professor Khaitan's view on academic arguments that often rely inadvertently on one or just a handful of cases?
Thanks for the question. I think the way to deal with that, both when you're researching the paper as well as when you are defending it in print, is to be upfront about your methodology. And the easiest thing to do is to assure the reader that you have looked at, for example, every case in which the Election Commission was a party before the Supreme Court, right? Or within the last 10 years, right? Now, one of the problems in the Indian context is that of volume, right? That there is simply so many cases that sometimes you have to do some, limitation exercise. As long as your limitation exercise is not contrived to suit your thesis, right? And you can justify it. So one way to do that would be to say, for example, that you're focused on a particular time period. I will look at cases in the last 10 years, last 20 years, because that is the current political context. Or you can say, I'll only look at cases decided by constitutional benches, right? And again, you can justify that by, say, citing Green and Yoon's paper that constitutional bench cases are sort of norm-setting cases, or that are error-correcting cases, or whatever, right? So you'll have to have a defensible methodology which is upfront. The best thing to do is to, and if a reader points out a case you have ignored, then take that into account, right? Which is why you workshop. If you can't do that, then have a methodology that's defensible when it draws the lines around the cases that you're looking at, and does not cherry pick. And look, it's a virtue to find a case. If you find a case that militates against your theory, you should not spend less time on it, but more, to say why it's an exception, why it proves your point, or why you need to modify your point in light of it, or why. So Mohsen, for example, shows one particular case, I think it was the electoral bonds case, I'm not entirely sure, which does not fit with the discursive democracy framework, right? Now that gives the reader confidence in the author, that the author is not trying to trick me. The author is not trying to hide uncomfortable facts from me, but is telling me, look, this case is an aberration. It does not fit my theory, but something interesting is going on. This case is exceptional either for political reasons, or maybe the court is changing doctrinally, or something else, right? So it's a virtue as a scholar to see what cases don't fit. But I would certainly endorse adopting a clear methodology upfront and telling the reader what the methodology is, and spending time to explain the case that stands out.
Can I add something to Professor Khaitan's remarks on this? So I'll give you one example of an additional difficulty apart from the problem of the large number of cases. The two cases which I use in order to explicate what I call the jurisprudence of deference are Mohinder Gill and I think Kanhaiya. And both of them adopt this language of plenary, etc., which we spoke about. Then there is another case I refer to, but I don't refer it in that section at all, and that is AC Jose, which is the first case on EVMs. Joe's case is its language is exactly the opposite to what I think it's a 1977 Mohinder Gill case. Joe's maybe 81, early 1980s. I need to check. And the argument there was literally the same from Gill. The argument was, why can't the ECI use EVMs? It is quote unquote plenary. It is unoccupied by legislation. And the court says, no, absolutely not. There has to be a law in place. They just can't go about doing anything. It's a poorly reasoned order. And it directly contradicts with the tenor, language, ethos of the previous cases. So this is a huge difficulty for scholars. I think in hindsight, and now I'll do it in the next reading, I'll have to put this in the footnote to say that, the court contradicts itself. But I do have a defense why I did not take AC Jose as seriously as that, because a lot of the value of certain cases is established through precedent in hindsight. The reason why, for me, Kanhaiya and Gill are so powerful in establishing the character of the ECI jurisprudence is because subsequent courts, subsequent benches rely on these two cases. Nobody refers to AC Jose, or at least it's not an interesting case for them. So in terms of the source of power of law, it is really what happens in these two cases. And that will be an additional difficulty and it's sort of a difficulty for all scholars who study India, right? That the cases are contradicting each other, the judges are not referring to earlier cases, smaller benches are saying opposite to what the larger benches are saying. And that's a problem that's not going to go. But I think, at least the way I have tried to deal with some of these things in this paper and outside, is just to put in on the footnote, to even sort of sometimes say that, this is from standard common law reasoning, it just doesn't work, but this is what is going on. And just sort of confess, because that is something completely out of your control. And still defend the kind of jurisprudential trajectory that you want to map. And say the reason why, in my case, the reason why I take certain cases and not the others is because they are the most influential cases. They are the ones which have been cited subsequently and really shaped the way the more important, bigger 5-7 judge benches have looked at the controversies before them.
Yes, thank you, Dr. Bhatt. Do we have any other questions? If we have the questions, participants may raise their hands.
While we wait, Professor Khaitan had a question. I just noticed that. And he asked me, well, should the intensity of judicial review of ECI then depend on its perceived independence? And if it is seen as non-partisan deference, if not more interventionist? That's a great question. And I do not, yeah.
I want to add to that, Mohsen. So part of the question is also, can the court do that doctrinally, or is this only possible in some political realist reading of the case law? So we know that courts are political actors. They're not political in the same way that parliaments and executive. They're attenuated political character. But I just wondered, whether there is any space in doctrine that allows the court any flexibility to, we know that the Indian Supreme Court is a polyvocal court and does not care that much about doctrine and precedents anyway. But being consistent with doctrine, can it shift the scales of intensity of review based on the perceived political environment? If the EC is seen as more independent, then it can take a hands-off approach. If the EC is seen as more partisan, it can be more interventionist. And secondly, is that sort of as a political institution, do you think it will be legitimate if the court does that?
Yeah, it's a very good and it's a good question. Obviously, I'll have to think much more about it, but very preliminary remarks. I think it's possible, and I don't know whether there are resources within India's ECI jurisprudence per se. But when I look at, say, for example, the German voting case, the court there is using the notion of public trust. And I think it's completely possible to build that into a strongly disciplined as possible doctrinal tool, which, if among other things, is also sensitive to public meaning and a certain public attitude towards the institution. I think that notion of public trust is quite powerful. That also is something which Mr. Tiwari mentioned in the beginning. And I don't see a reason why that can't be developed into something rigorous. And provided, of course, that the court says upfront that among the many criteria which you use to define what public trust is also sort of perhaps empirical questions. And courts have done it in all sorts of different public law controversies, to rely on surveys, to rely on what people say. Of course, there's always a danger of that slipping into something which is not rigorous at all. But I don't see a reason why it can't be developed.
Yes, thank you, Dr. Bhatt. So we've come to the end of today's workshop, and I hope, although after reading the paper by Dr. Bhatt, I found it very interesting and beautifully crafted in the manner, the structure of the article kept the reader's interest involved throughout. So, of course, I like the article, but then I'm sure that this workshop would have added few more insights, like the beautiful critique by Professor Khaitan and wonderful clarifications and questions by our participants would have definitely helped in making the fabric of this paper more homogeneous. So I personally loved the workshop, and I think it has definitely given some good suggestions to Dr. Bhatt. And I would like to thank all the participants for their valuable comments and questions. I thank Professor Khaitan for his role as discussant, and we all thank Professor Dr. Mohsin Alam Bhatt for taking out time and discussing his paper with all of us.
Thank you.
Thank you. Thank you so much, Swati.
Thank you.